Hello, my name is Carolina Marin Pedreno. I am a partner at Dawson Cornwell Solicitors, an international family law firm based in London. I am a dual qualified lawyer. I qualified in 2003 in Spain as an abogado and cross-qualified in England and Wales as a solicitor in 2006. I'm very grateful to the European Family Justice Observatory for their invitation to participate with this video in their project. I'm going to speak to you about practical considerations when dealing with cross-border family matters from a European perspective. We will go together through a case study, and we will always have as a reference that case study when we will speak about divorce, jurisdiction, applicable law, habitual residence, and also when we will speak about children, jurisdiction, habitual residence in respect of the children, and a potential wrongful retention or removal of the children within Europe. I hope you found my presentation helpful. I'm going to give you details of the case study that we are going to have as a reference for the rest of the presentation. The husband is a British national. The wife is an Italian national. They met in America, where they got married, and they moved to London. And from London, they moved to Mallorca. They have 2 children. The first one, the eldest one, is in boarding school in London. And the youngest one is in Mallorca. The parties have separated and the husband have moved to Germany, where he has some companies. And the wife has remained living in Mallorca. But is considering to move to London with the youngest child. So these are the most important facts of our case study, and we should keep them as a reference for the rest of the presentation. When dealing with cross-border family matters, the first thing that we need to have in mind is that it's very likely that we will have more than one member state with jurisdiction to deal with the family issues, in particular the financial, the divorce proceedings. In this particular case, the mother is Italian, the father is British, they have lived in London, they have lived in America, they are now living in Spain. So we need to consider in which country she should make an application for divorce. The legislation that deals with jurisdiction in matrimonial matters is the Regulation 2201/2003, commonly known as Brussels 2 bis. This regulation is concerning the recognition and enforcement in matters of parental responsibility as well as in matters of matrimonial matters. Article 3 of the regulation is the article that deals with the issue of general jurisdiction. When we will go together through Article 3, we will immediately notice that 6 of the 7 grounds of jurisdiction are based in the concept of habitual residence of the parties, or of one of the parties. So later on we will speak about the concept of habitual residence. So if we read together Article 3, we will see as follows. Article 3 says general jurisdiction in matters relating to divorce, legal separation, or marriage annulment, jurisdiction shall lie with the courts of the member state, A, in whose territory the spouses are habitual resident. So in this particular case, they don't have the same habitual resident. He's in Germany, she's still in Spain. So we go to the next ground. Or the spouses were last habitual resident insofar as one of them still resides there. So the parties' last habitual residence, we could say that it was Spain, and the wife is still residing in Spain. So clearly the Spanish court might have jurisdiction to deal with the parties' divorce. So one of the grounds here is established. Or we have other options. The respondent is habitual residence. So if we can determine that he is habitual resident in Germany, the German courts might have jurisdiction to deal with the divorce. Or, in the event of a joint application, either of the spouses is habitual resident. So it could be either in Spain or in Germany, if we can establish that they're habitual resident in those member states. Or, the applicant is habitual resident if he or she resides there for at least a year immediately before the application was made. So in this case, we know that the wife is considering to move to London. Can she make an application in London as soon as she moves? No, she can't. She has to become a habitual resident for 1 year before she can make an application to the English courts, according to this ground. And the next ground is based about the habitual resident, also nationality of the parties. So the applicant is a habitual resident if he or she resides there for at least 6 months immediately before the application was made. Either she is a national of the member state in question, or domicile in case of the United Kingdom or Ireland. So this wife, she is an Italian national. If she moves to Italy and she wants to make an application for divorce in Italy, as she is an Italian national, she will only need to become a habitual resident in Italy for the period of 6 months before she can make an application there. And the last ground that provides Article 3 is based on nationality of the parties. So it's 3b and say of the nationality of both spouses, or in the case of the United Kingdom and Ireland, the domicile. So it doesn't apply to this case because they don't have the same nationality. His domicile in England and Wales, in Great Britain, and she is Italian. So this is a ground that we don't have to consider. So going through Article 3, we can see that this, if we are representing the wife, she might have more than one jurisdiction where she can make an application for divorce. Currently, she can do it in Spain. She might be able to do it in Germany. She might be able to do it in in Italy, if she resides there for at least 6 months, becoming a habitual resident in Italy, as she's an Italian national, or she could even do it in jurisdiction of England and Wales, or in France, if she moves to that jurisdiction and she becomes a habitual resident in that jurisdiction for a year before she does the application. So clearly we have different options that we can give to her, and the best thing to do for her, it will be to take legal advice as to the outcome of an application for divorce in the different member states where she can make an application. So once we have the issue of jurisdiction clear, and we know what member states might have, the courts might have jurisdiction to deal with the parties' divorce, we have to have in mind Article 19 of Brussels 2 bis, as this article deals with lease pendants and dependent actions. I will read Article 19 to you. Where proceedings relating to divorce, legal separation of marriage annulment between the same parties are brought before courts of different member states, the court second size shall of its own motion stay these proceedings until such time as the jurisdiction of the court first size is established. So in this particular case, if the wife made an application before the Spanish courts, and on the same day or the day after the husband, made an application before the German courts, as the German courts are the second courts dealing with the same application, they should stay the proceedings issued by the father until the Spanish court establishes that they have jurisdiction. What this brings to the table is what is commonly known as racing to the court. So once the parties are advised as to in which jurisdiction it will be more advantageous to make an application for divorce, it is commonly advised to make the application as soon as possible, immediately, to secure the jurisdiction of those courts. So that is something that in practically has to always the practitioner has to have in mind when dealing with European family cross-border matters. When we have talked about jurisdiction in matrimonial matters, we have mentioned the parties' habitual residence as a key concept to establish whether the courts of a member state has jurisdiction or not. Unfortunately, we do not have a definition of habitual residence in the European legislation. From the jurisprudence of the European Court of Justice, in other areas, not in family areas, we can conclude that habitual resident has a connection with the intention to make that place the center of your interest. In any event, habitual resident it has to be established case by case, and it is a factual examination of in each particular case. There was a case between England and Greece where the parties were living in England, they moved to Greece, but the wife was working for British Airways, so she was traveling to Greece and between Athens and London frequently because of her job, and when the parties separated, she moved with the children back to London and issued a petition for divorce in London. So the question there whether she could acquire a habitual resident back in England and Wales within days after she separated from the husband and moved from Greece to England. So the examination of the intentions and the facts of the particular case, for example, if she has signed a contract, a rental accommodation for a long period, or the enrollment of the children in schools. So all of those factors are the key factors to determine whether a party is habitually resident in one member state in particular, when that habitual residence is disputed. The one of the most important jurisprudence in respect of habitual resident in England and Wales is the case of Marinos and Marinos. So I would recommend a good read of that case to understand the perception of habitual resident in the European community. Habitual resident differs between the divorce and children's matters. There is a small difference between these two. In our case study, the lady knows that she has different options regarding her application for divorce. She knows that she can make an application in different member states, and she should know now where it will be more advantage to her to issue her application. However, she would like to know what she has to do to get a resident order in respect of her children, and an order detailing which contact the father should have with the children. So the first thing that we need to determine is which courts will have jurisdiction to deal with these children's parental responsibility matters. The legislation is the same as for the divorce jurisdiction, is Regulation 2201/2003, commonly known as Brussels 2 bis. The article that deals with children's jurisdiction is Article 8. Article 8 is the foundation of jurisdiction in respect of children, and it's clear that the only courts that have jurisdiction in respect of children to deal with their parental responsibility matters are the courts where the child is habitual resident. Again, the concept of habitual residence is the key concept. We don't have a definition of habitual residence in respect of children matters, so we need to go through the jurisprudence of the European Court of Justice, and in any way it is determined case by case. Before I continue with the issue of habitual residence, I want you to know that it is common in the Mediterranean jurisdictions for these jurisdictions to deal with financial issues and children issues in only one main suit. So this means that when they make an application for divorce, they also deal with the issue of children. This is very common in Portugal, Spain, Italy, in Greece. So clearly the legislator has made things more easy for the European community, allowing parties to make an application for divorce in a member state and for a different member state to be competent, to have jurisdiction to deal with the children issues. If we go back to our particular case study, we know that the eldest child is living she's in boarding school in England and Wales, and the youngest one is in Mallorca. So if we start first with the youngest one, we will agree that there might not be disputes about whether he is or she is habitual resident in Spain. He's attending school in Spain, or she's integrated or he's integrated in Spain, all her friends are there, no problem with the language, they've been living there for consecutive years. So clearly the Spanish court might have the ones who have jurisdiction to deal with welfare issues in respect of that child. What happened with the eldest one, the one that is in boarding school? In this particular case, I will argue that the reasons why she is in England and Wales is only for education purposes, therefore she is still a habitual resident in Spain. Clearly, the examination of the facts in each particular case is going to be the things that will bring the answer to whether a child is habitual resident in one member state or another. Unfortunately, as I have said before, we do not have a jurisdiction. So in the practice, it's very important to consider every step that a person makes whenever they move to another jurisdiction, like making an application for a job, signing a rental contract, registering the children to attend school. So every step should be considered when they are dealing with, when there is cross-border family matters, as every behavior could be interpreted differently when we are examining the concept of habitual residence. Going back to Article 8 of Brussels 2 bis, in Article 8.1 it's clearly that habitual residence is the concept that determines jurisdiction in respect of children. We can see that the legislator has continued with the same idea, with the same foundation in Article 9, because they speak in Article 9 about lawful removal or retention of children from one member state to another. So when a child moved from, in this case for example, from Spain to England with the consent of the father, habitual residence doesn't change automatically from Spain to England. The legislator in Article 9 indicates that the courts where the child was habitual resident before he was lawfully removed to another member state retain jurisdiction for 3 months. We also have to consider that in the case where there has not been a lawful removal, if the father or the mother engage with proceedings in a new member state without disputing jurisdiction, that would be also a concept that he is or she is accepting that this member state where the child is now habitual resident will exercise jurisdiction in respect of that child's welfare issues. So as I have said before, every little step, every movement of the family should be considered and examined with care when we are giving legal advice. One of the cases that I will invite you to read to help with the issue of habitual residence in respect of children is the case of Mercredi. The general conclusion from all the ECJ cases is that in respect of children, habitual residence is determined according to the integration of that child in that particular territory. It's much easier to determine that child is habitual resident in one territory than an adult, because an adult can have a more peripatetic life. He can be traveling from jurisdiction to jurisdiction because of his work commitments. However, a child is normally more common to have a child in one jurisdiction during the week period, at least, because they're attending school in one particular member state. So now we can advise her that the Spanish court are the only court that can make, where she can make an application in respect of the children. Another issue that we could have in mind is that she doesn't listen to your advice, or she doesn't take advice. She has decided that they have broken down, they have separated, and she doesn't have anything else to do. In Mallorca, she's moving to London. She's removing the youngest child with her to be in London closer to the eldest child. She doesn't ask the father for permission to remove the youngest child from Spain to England. So in this case, we are talking about a wrongful removal of a child. Drafts 2 bis complement regulation, the Convention of 1998, the Hague Convention of the Civil Aspect of Child Adoption. Article 11 in particular and Article 10 deals with jurisdiction in cases of wrongful removal. And the legislator is also very clear in these cases that when there has been a wrongful removal, the court where the child was habitual resident prior to the wrongful removal or retention is the court who has jurisdiction in respect of that child. In these cases in particular, when we have a wrongful removal or retention, Article 11 as well enforced that message that the jurisdiction rests with the member state where the child was habitual resident prior to the wrongful removal or retention. Because in Article 11 there is a mechanism for when the child has been, in this case, removed unlawfully to England. The father will need to make an application to the English court for the child to be returned immediately to Spain, where he is habitual resident. So if the English court refused to return the child for exceptional circumstances, the Spanish court still remain exercising the jurisdiction, and if that non-return order is based in particular articles of the Hague Convention 1980, in that case the Spanish court could still make an order that that child should be returned to Spain. What I want to highlight with all of this is that it is very clear that when we are talking about children's matters, the issue of jurisdiction is very, very, very tightly connected to the issue of where the child is habitual resident. So it is we do not have the options that we have like we do in divorce proceedings through Article 3 of Brussels 2 bis regulation. I have tried to be simple and to give you just preliminary steps when dealing with a cross-border family matter. We will agree following the presentation that a key concept is habitual residence. But habitual residence is not just a key concept when dealing with divorce jurisdiction or children's jurisdiction. It's also a very relevant concept in other European regulations dealing with family matters, such as maintenance, succession, applicable law. So to know where our client lives is very important. Sometimes it's not a simple answer. To assist our client to acquire a habitual resident, or for him to secure his habitual resident or her habitual resident, might be very relevant for the outcome of his case. Please treat my presentation as an introduction to the rest of the videos, where particular matters and issues will be dealt with more detail. Thank you for your attention, and I hope that I have been helpful to you. Thank you.